Ladies and gentlemen, welcome back. We are now in the third panel of this afternoon. It is about open court and civil proceedings. And I have the pleasure of having three prominent and very different speakers. And I don't introduce them to you because you all have this nice description of the background of the different persons, but I'm very pleased that we have Cécile Chainais from Paris. She will start giving the civil procedural law perspective. Robert Magnus, who was my neighbor when I was in Heidelberg at the Institute for International Economic Law, writing his habilitation, first PhD, then habilitation, and now he has finished all that way, and he agreed that he would like to talk about this topic here. And President Wiwinius from the Supreme Court of Luxembourg, who will finally give us his view on the topic. You have the floor, Cécile.
So I would like to thank Professor Burkhard Hess and Dr. Anna Koprivica very much for doing me the honor of inviting me to take part in this conference alongside Judge Wiwinius and Dr. Magnus on this exciting theme of the principle of open justice in the age of information technology. It falls to me to consider this issue from a particular angle, that of public hearings in civil proceedings. I shall limit myself to a few points that appear to me to be salient, in particular by taking a comparative law approach that is, of course, by no means exhaustive. I begin by taking the liberty of referring you to my written contribution for a more detailed approach. The influence of the principle of public access to hearings is important. It is in vigorous health. The functions that Jeremy Bentham first assigned to the principle of publicity remain largely relevant today. Firstly, to encourage the accountability of judges. Secondly, to help the truth to appear and to educate people. And finally, to play a therapeutic role for citizens. Despite appearances, these functions are no less essential in civil matters than in criminal ones. As Dame Hazelden wrote, the civil courts reaffirm norms and behavioral standards for private citizens, business, and public bodies. Public civil hearings thus play an essential role in the social contract. Recognized by the main international treaties discussed during the first roundtable, the principle of open justice, and especially that of public access to hearings, is thus proclaimed in many domestic laws, sometimes in the Constitution, as in Spain, Italy, or Australia, sometimes in codes of civil procedure, as in France or Germany. In common law legal system, this principle was set out with vigor in famous judgments, from the decision in Scott and Scott in 1913 in England until a recent decision of the Supreme Court of Canada, which held, and I quote, "The open court principle is of crucial importance in a democratic society." And we shall keep in mind the striking metaphor used by the Justice Brandeis of the US Supreme Court to highlight the virtues of the principle of public access to hearings. Sunlight is the best disinfectant. Despite its well-established origins, the principle of public access to hearings is, in the digital era, confronted with new challenges. Firstly, the public hearing itself has profoundly changed. It includes more and more dematerialized matters. Even architects must take into account this dimension when they create the course of the 21st century, as will be the case in Paris in a few months. They must think of a dematerialized places of justice. But I will not dare to say more on this in the presence of Judith Resnick, expert on this topic. Secondly, that portion of the public likely to attend a hearing has been deeply renewed and enlarged. Whereas for a long time, open hearings went hand in hand with immediacy and physical presence, it is now possible to consider that the public that should benefit from open justice is an indeterminate public, a public without borders, capable of attending a digital trial made available online. This is how the Supreme Court of Canada became in 2009 the first national Supreme Court to webcast its hearings, and I quote, so as to increase awareness and transparency. However, this broad understanding of publicity is likely to conflict with other principles recognized as fundamental, such as the principle of the right to privacy, trade secrets, or the right to safety. How, indeed, can we reconcile unlimited access to civil hearings with respect for the privacy of the persons involved in the matter, whether they are parties, witnesses, or even judges? How can we avoid, particularly in commercial matters, that very wide access to a civil hearing does not contribute to breaching commercial confidentiality? These questions were already being asked when there was a narrow interpretation of publicity. For this reason, most European legislations traditionally provide statutory exceptions to the principle of public hearings in instances where the case involves privacy, trade secrets, safety, or grounds of public policy. It is remarkable that but these questions are even more acute at a time when information technology allows an unlimited virtual audience to be reached. Technology is indeed acting as an echo chamber. It amplifies the effects of each breach of these individual rights. It is remarkable that sometimes this echo chamber effect of technology may affect the internal equilibrium of the proceedings. This could be the case where a party to civil proceedings starts turning the platform of court proceedings into an advertising hoarding for his commercial or private activities, or where judges are the subject of repeated aggressive tweets throughout the hearing available online. The serenity of proceedings and the impartiality of the judges could be compromised, or where the witnesses fear that they will be the victims of cyberbullying. They could be discouraged from testifying. These situations raise delicate questions. How can we avoid the risk of proceedings being hyped due to overexposure in the media, facilitated, for instance, by a live webcast? How do we prevent the intrusion of electronic devices like smartphones, camera phones, laptops, etc., from disturbing the ritual of the courtroom? It is totally foreseeable through these questions the very notion of fair trial is being threatened. If we do not take the full measure of the risk, then open access could have a counterproductive effect and infringe the integrity of proceedings. If we are not careful, a poorly controlled application of open justice could even divert people away from public forms of justice in favor of private justice. The right to access a judge could therefore be compromised. This is even more paradoxical, given that in some countries, such as Australia, open access is considered by the Constitution as an essential element of integrity of the court. Two forms of integrity begin to compete. Worse yet, people could be tempted to return to forms of private vengeance. In Aeschylus Orestia, the institution of a court rendering its decision in public, Areopagus, allowed the Greek city to chase the goddesses of vengeance, the Erinyes, from within their walls. Let us be careful that a poorly managed understanding of public access to the same court does not provoke, in the digital era, the return of the Uranus to our modern societies. At the same time, it seems to me that we need to avoid an outdated interpretation of publicity. Denying the contributions made by the development of technology would be nonsensical. The vision of public access to hearings that prevailed at the beginning of the 20th century, limited to the public that was physically present in the room, is outdated in a way. Carefully conceived, the modernized principle of open justice, which is fundamental in a democracy, should be able to draw on all the strengths of technology. Digital access to hearings could thus support the educational function of the trial. In the same way, it could usefully meet the public demand for quality and transparency in justice. This could be precious at a time when the courts can be the subject of a great public distrust. Chasing information technology out of the courts would therefore be a fruitless and anachronistic position. We therefore need to seek a balance between these various concerns. How then can we reconcile the principle of public access to hearings with the protection of certain fundamental individual rights? How do we regulate this competition? My presentation today will attempt to provide a few answers. First, the implementation of new technology within civil proceedings seems to be giving rise to a new judicial ritual, which leads to a rethink of civil public hearings. Secondly, the external use of these technologies creates a new worldwide audience for these rituals. We seem to be watching a redefinition of publicity, which could lead to the birth of a new kind of courtroom, conceived as a new global Benthamian panopticon, which raises many questions. This will be my second point. Finally, this finding makes it necessary to seek out a new statutory framework capable of handling this new state of affairs. This will be the last part of my presentation. Due to time constraints, I suggest that I move quickly through the first part of my reasoning, which will be more developed in writing. The use of technology within proceedings profoundly modified them. Firstly, submissions are more and more frequently dematerialized and written. Secondly, modern changes to civil procedure affect public hearings in more or less radical ways. Sometimes the public hearing is simply abandoned. An electronic court therefore rules without a public hearing and on the basis of a purely digital case file. It was present in the online dispute resolution report of 2015. I move on. Secondly, sometimes, less radically, the very philosophy of the public hearing is changed. For instance, video conferencing destabilized the traditional judicial ritual as highlighted by William Arnold or Antoine Garapon. In particular, it compromises the three-unity rule, time, space, and action, especially space. Indeed, it challenges the standard of physical presence, which requires witnesses and parties to be physically present in the room. In addition, it compromises the principle of immediacy, dear to Chiovenda and Capelletti, principle by virtue of which the judge should be directly in the presence of all the physical spectacle of the hearing. Sometimes the hearing itself can be subject to audiovisual recording, capable itself of becoming evidence in the procedural file. This step was recently taken in Spain. all public hearings are officially videotaped thanks to a public recording organized by the courts themselves. The parties and their representatives may ask the clerk for a copy of the filmed hearing, which is an element of the procedural record. This is very useful for the judges at second instance. According to the Spanish authors, the judges' awareness that they are being filmed tends to increase their sense of accountability and to raise the quality of the hearing. But in a very interesting way, following this reform, a debate has arisen in Spain. Should the video recording of the hearings, originally for the parties to the case, be made available to any citizen who requests it by virtue of the constitutional guarantee of publicity? This question is perfect, good transition to my second point. So I go a little quicker. My second point, which will be the question of the redefinition of publicity. As Adrian Zuckerman says, the principle of publicity has several aspects: a public aspect and a litigant-related or party aspect. The public aspect implies that members of the public have a right to attend court proceedings. According to the party aspects, parties to civil proceedings have a right to insist that their dispute is adjudicated in the public, in a place, that is accessible to the public. I would say that the increasing use of ETs has deep consequences on the public dimension of this principle. Taking notes and disseminating them through the internet, tweeting, video, TV broadcasting, webcasts, all these techniques constitute new paths for transparency and maybe for a new conception of publicity. Citizens could consider that they are entitled to demand an updating of the public dimension of the principle of publicity. In that perspective, the development of electronic technology would create a duty for the state to adapt and to offer to citizens the best electronic public access to hearings. Opening the physical doors of the courtroom would suffice no more. The judicial machinery should allow all the people of a country to attend the hearing electronically, remotely. The judicial stage would be a global Shakespearean theater with a worldwide audience. This sudden entrance of a new virtual audience that is not present in the court raises questions. It could indeed destroy the traditional view of publicity, which holds that public can be physically present in the room. Should we change the model? Should we switch from the principle of courtroom publicity to the model of electronic publicity or worldwide audience publicity, rendered possible first by television, then by the internet? Prima facie, this would reinforce the accountability of judges. In this regard, the Benthamian conception of publicity, the judges in a trial, on trial, would remain perfectly relevant. Indeed, in a way, those electronic devices make the courtroom operate as a huge modern Benthamian panopticon. Indeed, the courtroom finds itself at the heart of an apparatus that recalls in a particular way the Benthamian prison described by Michel Foucault in his works. When, for instance, a trial is webcast live, the judge does not know for sure that someone is actually in front of a screen watching the trial. The public cannot be seen by him. They might all enjoy their Saturday night in a more traditional way and not be there. But the device creates the sense of being inspected and increases the accountability of the judge. By device, I mean the existence of the camera and the ability of the public outside the courtroom to see without being seen. At the same time, the metaphor of the panopticon also raises complications and questions. Is it really desirable that civil trials can be seen by anyone and in any circumstances at any time? the question is one that demands an answer. Behind the figure of omniscience and the panopticon, the preservation of privacy, trade secrets, and the safety of the parties are all at stake. The renewed conception of publicity indeed conflicts with other fundamental individual rights themselves affected by the development of information technology. As Karen Eltis showed, the dawning of the digital era led to a renewal of fundamental notions, starting with the protection of the right to privacy. Previously, and this is the first column of the table, the protection of the right to privacy first supposed the prohibition of the disclosure of sensitive or personal information that might harm the person concerned. The protection of the right to privacy thus rested on the paradigm of secrecy relating to sensitive or personal information whose confidentiality had to be ensured. From this perspective, the fear of an Orwellian universe was highlighted. Today, and here is the second column of the table, a breach of the right to privacy may result from a much more diffuse phenomenon, less immediate and less visible, rendered possible thanks to the digital revolution, what Daniel Solove in the US called aggregation of information in relation to a particular individual. Massive electronic aggregation of matters that, taken alone, would be anodyne, allows a digital biography of an individual to be drawn up in total breach of the right to privacy. The fears then becomes that of a Kafkaesque world in which the state or private individuals can gather together a tissue of information that is never really accessible as a whole to the person concerned. In this context, a civil hearing, which is accessible online, along with all of the other informations that it carries, risks amounting to another item in this unfortunate digital biography. It could also breach the right to be forgotten that the European Court of Justice recognized. As you can see, there is a risk of diverting the traditional functions of publicity. Public access to civil hearings might be manipulated for the purposes of breaching the right to privacy or trade secrets. Publicity, supposedly the soul of justice, said Bentham, could in fact become its grave digger. It could be, in certain cases at least, the Trojan horse of breaches of parties' rights. Therefore, it is essential to seek guidelines to redesign the statutory framework for the principle of public access to hearings in the digital age. Here comes the third point of this presentation. Before seeking a new statutory framework for the public access for civil hearings, one should be aware of the extreme heterogeneity of the solutions suggested in positive law. From one country to another, and sometimes even from one court to another, the way in which these questions are approached is extremely varied. Firstly, some countries have organized institutional footage of the hearings, whereas others principally ask this question with regard to footage from the media or from private individuals. Or these are two different situations. In the first case, the footage comes from the institution itself. It is an hypothesis increasingly common, even far from being general. Sometimes it is a generalized practice. It's a generalized practice in the country, as in Spain. Sometimes it is a practice limited to a particular court, for certain Supreme Courts, for example. One can also note a diversity of technical implementations Sometimes just a copy of the recording of the hearing is provided. Sometimes it is webcast. Sometimes the webcast is live. Sometimes it's delayed. There can be a direct access to the webcast hearing. Sometimes it's upon authorization. The diversity is really striking. But most of the time, we arrive to a second situation. Institution does not itself provide audiovisual recording of the hearing. And even when it does so, media outlets or private individuals may also wish to film proceedings by their own means. It is the second case, the one of non-institutional recordings. Again, we can see that comparative law provides widely varying answers to the situation. If one were to attempt to systematize these diverse approaches, one could say that two technical models appear to stand out in comparative law. Whereas many systems set out a general principle of prohibition of electronic coverage of the hearing, it is the first column of the table, others, which are fewer, set out the inverse principle, that of presumption of authorization. We shall begin with systems with a general principle of prohibition, so let us focus on the first column. Indeed, these systems maintain a presential conception of publicity and object to the intrusion of traditional or digital cameras in the courtroom. From this point of view, they are more traditional. Germany would be one of them. In these systems, the rule of prohibition simply has exceptions that are subject to conditions, and the onus of establishing that these conditions are met is on the applicant. However, within this model, one actually can observe a wide variety of approaches. Some countries implement a scheme of exceptions that is tightly restricted. In this case, the most widely accepted exception is to allow the judge to authorize a derogation for educational or instructional purposes. Other countries have made increasingly broad exceptions to the principle. Interestingly, the Ontario Civil Court Act adds to the educational purpose exception the possibility for the judge to give an authorization where required for any purpose of the court hearing. Besides, other countries provide that the judge may give an exceptional authorization to film a specific case independently of any educational purpose. Some of them take into account the risks that are linked to this exception. As instance, the policy of the Provincial Court of British Columbia precisely that this particular authorization can be granted only provided that the broadcast of the hearing will not affect the right of a party to a fair trial or interfere with any privacy interests, etc., etc. Let's see the second column. Those are systems with a presumption of authorization. These systems took an additional step and adopted what appears to be a second model. They set out the inverse rule, namely the presumption of authorization of electronic film coverage of the hearing. Doing so, they implicitly approved not a presential but rather a virtual conception of publicity. This presumption was set out by the Spanish Constitutional Court in 2004. Reversing its previous case law, it held that the recording of sound and images during a hearing was only a manifestation of the principle of public access to hearings. At the same time, it preserved the possibility that courts may forbid such recording exceptionally in order to protect image rights and right to privacy. Besides, as Emily Hittner showed, certain American states have created a presumption that electronic media coverage is allowed in proceedings that are accessible to the public. The same goes for Utah and Kansas, USA. However, as in Spain, exceptions allow for this presumption to be rebutted, in particular in consideration of factors such as the right to a fair trial, privacy concerns, and safety interests. This leads me to the seeking for a common frame. Given these disparate regimes, it is easy to see the need for a new statutory framework. While it is too early to propose a uniform framework, we can at least maybe give a rough draft of some guidelines for harmonization. For institutional recordings first, first point is the necessity to develop a common framework for the reuse or capture of official recordings. It is important that the most ambitious solution would be that each legal system organizes the recording of its hearings and that it determines its broadcast conditions subject to the respect of the parties' rights. By way of example, the UK Supreme Court, which provides for the broadcast of its hearings by webcast, specifies that, I quote, the reuse, capture, or redistribution of this footage in any form is not permitted. Besides, it appears to me that it falls to courts or legal systems to take the necessary steps to protect the parties' rights. One could imagine several ways in which this could be done. During the hearing itself, with the anonymization of the parties, but I think it could be complicated technically. And before broadcast, certain techniques could be implemented, blurring faces, beeping out names, etc. And more generally, I suggest that maybe two ICSID webcast rules could be applied to public civil hearings when webcast. Firstly, webcast should not be broadcast live, but always with a delay, even a slight one, so as to avoid making available a moment from the trial that compromises the parties' rights. Secondly, during a public hearing, the lawyers should be able to indicate to the judge that a confidential exhibit is about to be discussed. A suspension of the recording could be granted for the duration of the discussion. It would be a proportionate measure. Lastly, the trial could be made available online only for a given period and in conditions that then guarantee the right to be forgotten. To conclude, I turn to the most frequent case in which the recording is not institutional in origin, but is made by media outlets or private individuals. Here again, it seems that we may lay out a few guidelines. First guidelines, modern legislation should adopt texts, even simple court protocols, to govern the use of information technology within them. But the question cannot be handled at the national level alone. Eventually, the European institutions should continue to deal with this issue. Second guideline, this text should ensure that real power should remain with the judge to decide in each case on the proper use of technology. From this basis, it is ultimately unimportant whether there is a presumption of authorization or principle of prohibition over the recording of the hearings. The main thing is to allow the judge a broad margin of appreciation to exercise his power. Third guideline, in taking his decision, the judge must use the principle of proportionality to give adequate protection to the rights of the individuals, while preserving as far as possible the central value of public access. One must ensure that the use of communication technologies does not breach the rights of the parties. It must therefore be implemented both proportionally and reasonably. For example, a balance must always be found between the privacy of confidential business information and the principle of open justice. This need has been recognized by the English court in several cases. And this concern for balance now has a European basis, since the adoption of the Trade Secrets Directive of 2016. According to Article 9, to preserve confidentiality of any secret during a legal proceeding, judges must take measures such as restricting access to hearings. Judges must assess the proportionality of these measures, taking into account, for instance, the right to a fair trial, the legitimate interests of the party, etc. Besides, common law has in fact developed a precise approach of this proportionality test, a principle of necessity and then a principle of proportionality proper. And interestingly, we find the same requirement in the preliminary article of the new Code of Civil Procedure of Quebec, which sets the principle of procedural proportionality, which applies in particular to the use of electronic technology in courtrooms. Fourth guideline, in any event, the power of the judge to exclude public access should not be purely discretionary, but reasoned. Judge must give his reasons. The public prevented from attending a hearing should know the reason why the breach of the principle, the reason of the breach of the principle of open justice. Following this expose, we can measure the complexity of the questions we are addressing in this conference. Certainly, sunlight is the best disinfectant, as Justice Brandeis once said. But the need to protect a number of fundamental rights in the era of new technologies requires more than ever that some shade is retained. Ultimately, the statutory framework for publicity should be in light and shade, in chiaroscuro, the pictorial technique of the Renaissance. The issue is to ensure that justice is manifestly and undoubtedly seen to be done while preserving legitimate areas of obscurity. The Renaissance, the rebirth of the principle of open justice in the digital era comes at that cost. Thank you for your attention.
Thank you very much indeed, Cécile, for taking up this perspective and giving us an idea what the digitalization may entail for civil proceedings and for the hearing. And we must be aware these developments are here. We cannot avoid them. And the law has to react to them. And the law is always behind. And it was fascinating to see how diverse the approaches are. And here we also have a new landscape to map out with regard to these influences and to come to common solutions. I fully agree. Just to give one idea, there is an expert group of the European Commission on the evidence regulation, and we are dealing with video conferencing under the evidence regulation. And here, many of the questions you ask will appear and have to be solved. So thanks again. And now a German perspective. I don't know whether it will be conservative, but you will tell us.
Kind of modern, I hope so. And I deliver them standing. Ladies and gentlemen, as a famous songwriter once said, the times they are changing. And I want to add, they are changing fast. Only in the year 2001, the Minister of Justice for North Rhine-Westphalia wrote in a legal journal that we are living today in a society which could not have been imagined back in the 60s. The primary sources of the information for the citizens, so the minister said, are no longer the print media, but television and radio. From this perspective, the year 2001 seems to lie in another millennium, and we are living today, once again, in a society which could not have been imagined back in 2001. Today's most important source of information is by far the internet, including official websites of publishing houses, or the government's blogs by prominent or not so prominent persons, the social network, and so on. This digital revolution has led to major transformation in almost every field of our modern society. The legal branch is by far no exception. As Professor Chainais rightfully pointed out, there are two possible influences of the new media which have to be distinguished. On the one hand, the question arises how the court should or could adapt to the new technologies within the courtroom and during the public hearing. On the other hand, the changed flow of information might as well influence the way in which hearings and court proceedings in general should be presented to the public. I will start with the first issue and will afterwards address the second. Although there are many different and very complex questions involved, I will try to keep my speech very brief. Recently, statements have been made that in the future a public hearing might be superfluous and the day in court will be substituted with a video conference, allowing all parties and the judges to stay at home, and the proceedings will then be undertaken in virtual rooms and via live streams. In my opinion, this is a vision of the future which is neither very likely nor desirable. As proceduralists of different generations and in different centuries rightfully pointed out, the public hearing in court within the physical presence of the parties, witnesses and judges has its undoubted merits, which cannot be substituted at all. Especially when the trustworthiness and credibility of a witness is in doubt, it is of essential importance that the judges have an immediate and direct impression of this witness. This impression cannot, with the same effect, be delivered via video or substituted with a video interview. The physical presence of all parties concerned is also very important when the court is trying to settle a dispute amicably, which can also be seen in the area of alternative dispute resolution. For this and other reasons, I think the last day in court is not yet to come, and the influence of the new media on the public hearing in the courtroom will always be rather limited. On the other hand, a video interrogation of an expert or witness is better than no interrogation at all. If all parties concerned agree on such a procedure and the video interrogation is useful to save time and money, I see no reason why it should not be allowed. Nevertheless, the video conference will remain an exception with rather limited use in very specific circumstances. Another question, which was not yet so much in the focus of the recent discussion, is whether or not the public hearing should be recorded via camera or audio devices, and whether this record should afterwards be made available only for the parties and the court, as we have learned today is the situation in Spain. In my opinion, such a recording would have its merits, especially in very complex lawsuits, stretching on for years and years or maybe even decades. The exact content of a witness statement made in a public hearing years ago will not be present anymore when the judges eventually come to their decision. In such a situation, the video or audio record might prove to be a very useful tool. This even more so when a lawsuit covers several instances and the judges sitting in the appellate court have to decide about potential errors and flaws in the procedure of the court in the first instance. The arguments brought forward against the use of such a record, in my view, not very convincing. In a society in the century where almost every action is filmed and uploaded via YouTube on the internet, the intimidation of witnesses and party by the mere presence of a camera, like we have today, also a camera here present in the courtroom, is not very likely, especially since the use of the recorded action would be strictly limited to the court and the parties involved. A further potential conflict not yet solved lies in the question how the court should deal with the use of electronic devices in the audience. Should the spectators be allowed to Twitter their impressions of the public hearing or to post them on a live stream on the internet? Judge Paulus has said some words to this phenomenon quite recently adjudicated in Germany. Different solutions for this problem can be found in different legal systems. The more modern approach, practiced for example in the Netherlands, seems to allow such a use as long as it does not interfere with or disturb the public hearing. An unwelcome influence of this posting on witnesses waiting for their hearings outside of the courtroom doors can quite easily be prevented by simply lodging them in a room without access to the internet. The filming of a hearing via smartphones in the audience might, on the other hand, stretch the boundaries too far and cause problems with regard to the protection of sensible data. Another problem which has arisen quite recently in Germany in connection with the trial against the terroristic neo-Nazi society, the NSU, was whether or not, and according to which criteria, representatives of media houses should be given priority access to the limited space in the courtroom. Here, the changed landscape of the media in the age of internet and smartphones come into play. If there is a priority access for representatives of the media, which the German Federal Constitutional Court has strongly supported, who should represent the so-called new media, the internet blogs, the homepages, the Instagram accounts, and how are their representatives distinguished from the ordinary audience? Is, so to say, every small blogger part of the press and can therefore claim priority access? These are questions which lie at the very heart of the constitutional guarantee of the freedom of the press. They probably require a different concept and a new understanding of the role of the media in the transmission of information in a modern society. I want to proceed with some short remarks to my second issue, the possible presentation of the public hearing outside the courtroom. It has been discussed at length today whether a live recording and distribution of the public hearing on television or on the internet is desirable or advisable. In my view, such a feature should only be considered in specific circumstances, since in most trials the protection of the privacy of the parties and potentially negative influence of the statements of witnesses or the parties will hinder a worldwide broadcasting of the public hearing. Potentially more restrictive options might include the TV broadcasting of the pronouncement of the judgment of the Supreme Courts, as has recently been introduced into German law, or even of the public hearing itself before such courts. Another possible option also discussed today would be that instead of a live recording broadcasted by a TV channel, only a revised or censored version, a TV summary of the public hearing will be made available on the homepage of the respective courts, as is done, for example, at the European Court of Human Rights. In the age of fake news and conspiracy theories on the internet, the fight for the truth and the correct information is of crucial and vital importance. This is also a task the judiciary should not at all neglect. Clear, structured, transparent and regularly updated homepage, officially administered by the legal institutions themselves, are such not only a regular service to the public, but a necessity. Whether such regular updates and transmission of information by the court should also use other media such as Facebook, Twitter or Instagram is on the other hand rather a question of style. In order to increase the visibility of the court system also for the younger generation, a greater flexibility and rather unorthodox ways of presentation might be useful and maybe also advisable. I am coming to my summary. The internet and the flow of information changes everything, but as far as the public hearing and civil procedure is concerned, the changes might not be as fundamental as some authors expect. The day in court is a legal tradition that has been established for more than 2,000 years, and there are good reasons why it will and should outlast another few centuries. And finally, to quote another songwriter, I think something else still remains crystal clear. The revolution will not be televised. The revolution will be live. Thank you very much.
Thank you very much, and I would like to invite President Wiwinius to give his views on this topic. I have already seen that we have different approaches, and this is good for a short but intensive discussion we will have. Mr. Wiwinius, the floor is yours.
Yep. Good afternoon, or let's say good evening, everybody. I also would like to thank the Max Planck Institute and Professor Burkhard Hess for inviting me to take part in this high-level and exciting conference. I act as a judge since more than 35 years now. In this regard, please note that I enter into the debate less than a scientist. I'm not a professor, I'm not an academician, but rather than a practitioner. A national judge, an ordinary court, and I'm acting in the courtroom. So I will not speak about philosophy, no Hegel or Beccaria, neither Shakespeare or Kafka. Since the very first interview I had the opportunity to grant a journalist after becoming president of the Supreme Court in Luxembourg in 2016, I have been asked questions about not only the very important subject of the independence of justice in Luxembourg, but also about the transparency of justice, access to justice, thus the topic of the present conference, open justice. Courts, especially national courts, are often criticized for lacking transparency compared to the other two branches of state power, executive and legislative. Transparency plays an important part in the rule of law. Transparency allows the citizens to be kept informed, enabling them to develop a better understanding of the functioning of our proceedings and the different workings of the courts, thus narrowing down the gap between courts and society. Even if opening up the courts to the public and improving judicial transparency is a huge task, this ought to be done. Transparency enhances indeed the public's faith in justice. I think it already has been said today. And public trust in institutions is based in public trust in individuals, I mean judges. It is no secret, and the discussions of panel 2 that we heard that we had earlier have been proving this, that what captures the journalist's interests is drama, namely the criminal trials, sex and crime, Mord und Totschlag in German. The civil proceedings are, from the media's point of view, of much less interest. Nevertheless, having served for many years as a civil courts judge, as well as in my new function as president, or new since 1 year and a half, in my function as president of the Supreme Court, I feel compelled to show to the public that justice is not only made of criminal cases, but also and mainly of civil cases, including commercial, labor law, social security disputes. At our Court of Appeal in Luxembourg, for instance, of the 11 chambers, only 3 focus on criminal and correctional matters. And I also committed myself to describing to my interlocutors what is happening in those jurisdictions. To one of the first questions I have been asked concerning my projects, I replied that I intend to stress the visibility of justice, if possible and necessary. In fact, giving visibility to justice is part of public service and is an area where things remain to be done to show what justice is. This may, moreover, also enhance the quality of justice. In this context, I think we, as judges, have to adopt a more proactive approach towards the media. At a time when citizens become more and more suspicious of other institutions, I mean politics or media, for instance, this increasing visibility of justice should help maintain everyone's trust in justice. When delivering a speech to explain my work to friends, to students, social clubs, etc., I always observe 2 things. On the one hand, I find that people know very little about our work. But on the other hand, they are very interested in what we do. I always have the feeling that they listen to my speech until the end, even late in the evening. However, I also notice that the big challenge remains the technical language, which is based on the precise application of legal regulations. Thus, conveying the educational impact of legal proceedings and court decisions is not always an easy task. Until recently, transparency meant freely entering the courtroom, observing the court's proceedings, and hearing the court's decisions. And in order to do so, the public had to go to the courthouse. Today, however, we heard it today several times, the public has a different understanding of what the transparent court system means due to technology, which makes everything readily available. Nowadays, we mainly speak about online transparency, meaning that court proceedings and all relevant aspects of court performances can be made remotely available to the people in a form that they can grasp. Courts are in principle open to all citizens wishing to attend the public hearing, but in practice, we know very few people have the time or the opportunity to personally see what is happening in our courts. People therefore rely on television and the internet to access information. This fact combined with the huge growth in information technology, has raised people's expectations to be able to see and hear things by themselves. I am therefore under certain conditions, in favor of filming or recording in the courtrooms. Indeed, there is no doubt that the presence of TV cameras during the proceedings may disturb people involved in the trial. I mean the judges, prosecutors, lawyers, parties, witnesses, etc. Some of them, of course, seeking publicity, and may even alter their behavior. Therefore, I consider that broadcasting should be limited to the public pronouncement of the judgment. And filming or recording should only be done with the permission and under the supervision of the court. Needless to say, access to information must also go hand in hand with an accurate and fair reporting. Journalists should be trained to report on legal issues and proceedings so that they can provide intelligent and sound accounts of what is happening in courts. This could also avoid the public pressure that is put on judges, often through social media. In Luxembourg, as in many other countries, judges mainly express themselves through their decisions, which they should not comment in the press. I, however, wonder if it would not be appropriate, concerning trials of major public interest, to allow the judge to briefly explain his or her decision after its public pronouncement and, if necessary, to clarify in simple terms the main points and arguments of the decision to the journalists. Moreover, representatives of the judiciary, with the authorization of the hierarchy, of course, should also not shy away from giving interviews in public on general legally important issues. Mr. Ambassador, good evening. Press releases in the court's website and on general website accounts are additional ways of informing the public about the main court events. Another of the peculiarities of the open justice lies, in my opinion, in the language used by the justice officials, both in writing and orally. A simple, concise, and clear judicial language is beneficial to everybody, as it makes the rule of law accessible and foreseeable for the citizens. Judgments must be interpretable and understandable, not only by lawyers, but also by non-lawyers. As far as the spoken language is concerned in Luxembourg, in oral hearings, we speak Luxembourgish. But if you prefer to express yourself rather in French or in German, you may also do so. But not in English, that's a foreign, very strange language, usually for us. As far as the written decisions are concerned, the legal language is French. In our judgments, we cultivate the French language to the point of accurately applying the appropriate rules of punctuation, very strict, especially in the Court of Cassation. Another important aspect of the transparency of justice is that an independent, non-corporatist body, a lot of countries know this body as a Council of Justice, is competent for the appointment of judges. I dedicated my inaugural speech as President of the Supreme Court to the independence of the judges. I outlined that one of the most important aspects concerning this independence regards the judges' selection, the appointment, their career. The rules to this effect are crucial for the quality of the judicial system, for the trust in justice, and for the degree of the judges' independence. I therefore felt that measures had to be taken in order to introduce procedures for the appointment and promotion of the judges which are transparent, based on objective criteria relating to the exercise of a public function, focusing above all on the candidate's skills and experience, thus his merit, and which are obviously free of political interference. I also outlined regarding the designating authority that it is widely acknowledged on an international level that this authority must be independent of the executive and legislative branches of government. But I think we will speak tomorrow about the appointment matter. Apart from access to the courtroom, I think we heard nearly enough today about public hearings. I have two other matters to tell about. So apart from access to the courtroom, another important aspect of the access to justice seems to be is the access to jurisprudence, which means broader publication of the court decisions, an aspect that I think has not yet been touched today. What effects will result from a wide access to jurisprudence? For instance, the outcome of certain cases may become predictable. The most predictable cases may be settled beforehand. The legislative interest in jurisprudence is also enhanced, and the legislature, understanding how courts are interpreting and apply certain laws, receive a feedback, which furthers and assists the development of legal regulations. That's the aspect lawyers, but also researchers and university professors, there are enough of them in this room, are mainly interested in. I have repeatedly been approached by editors of certain law journals, professors from the University of Luxembourg, and also researchers from the Max Planck Institute, pointing out that Luxembourg is lagging behind numerous other countries in this regard. This isn't false, and we could do more. It is right that all the judgments of the Court of Cassation and the Constitutional Court may be retrieved since 2007 in a fully anonymized format on the website of the Justice. The same applies for the decisions of the administrative jurisdictions, which are totally available to the public. The important decisions of other jurisdictions are listed mainly in the Pas-y-Crézy and other compilations such as the Journal des Tribunaux. But of course, this is not enough. There are many important judgments from the courts of first and second instance which must be brought to the knowledge of the public, lawyers, and researchers. Where does the problem lie? Considering that technology makes everything is possible. Since several years, those decisions have been available in electronic format on the Justice's intranet server, which is accessible to all the judges. But then why have they been made available only to them? The major problem remains the necessity, if not the requirement, to anonymize the court decisions. This is an enormous undertaking. Allow me to make a personal comment on this. Of course, I am in favor of the anonymization. This morning we had a deliberation at the Court of Cassation, the délibéré, and during the coffee break, the pause, we trained together, my colleagues and me, for this anonymization word. I don't know if I managed to do it, but I think you know what I mean. Anonymisation, en français, c'est pareil. So I mean, I'm in favor, generally speaking, of the anonymization of decisions concerning private aspects of people's life, such as divorce decisions or juvenile cases, for example. There is no need to expose everything to public view either. But on the other hand, we should not go too far either. The big defender of the human rights and the rights of the defense, the European Court of Human Rights in Strasbourg, has all its judgments published, and many of them are not anonymized. The judgments of the international courts are quoted by the name of the concerned person and not by a number. For example, most of the leading cases, the Procol ruling, the Camp judgment, Van Gent and Loos, Kohl and Decker, Google versus Spain, etc. A few days ago, I participated in Strasbourg at the solemn hearing to mark the beginning of the European Court of Human Rights judicial year. President Raimondi and President Leenaerts of the European Court of Justice here in Luxembourg didn't stop quoting the key judgments by the name of the parties. And 2 hours ago, Vice President Nussberger did the same. They spoke about Navalny, Berlusconi, and other eminent persons. So I believe, indeed, that by over-anonymizing, you know what I mean, we should not fall into the opposite extreme, nor into a ridiculous situation. I recently spoke at the Forum of Judges organized by the European Court of Justice here in Luxembourg to my German colleagues. In Germany, rules regarding the anonymization question are very strict. We cited by way of example one decision where one of the parties was referred to us as Frau Kanzlerin M. This is Chancellor M. In French, you would say plus ridicule tu meurs. In this context, everything is a question of achieving a balance between data protection and right to privacy on the one hand, and openness of justice, transparency, access to information on the other hand. There's no discussion. According to Article 8 of the Charter of Fundamental Rights, we must ensure that personal data is protected. However, the right to such protection is not absolute and must be reconciled with another fundamental right enshrined in Article 47 of the same Charter. You already heard about it, namely the publication of judgments. A public justice is also a fundamental principle of the state grounded on the rule of law. It is thus essential to find the right balance between the publications of judgments and the protection of privacy. Needless to say that transparency also promotes accountability, the accountability of judges, but this is another issue which merits to be discussed more in depth during another conference. I want to conclude by saying, if Luxembourg is not a forerunner of the open justice, I think that especially the Baltic states, and some Scandinavian states are. Nevertheless, we are on the right way to becoming so. Compared to some years ago, there are less reluctances to opening the doors to the public, and I am convinced that the leaders of the judiciary, together with the Ministry of Justice, will achieve sooner or later, I hope and I think sooner, this goal. And as a judge, I would say we have a great deal to win and little to lose from being transparent. I thank you for listening, and I hope there's time enough for the reception. Thank you.
Thank you very much, President Wiwinius, for this speech, and the visibility of the justice system is something we have to keep in mind. It is a very important institution, and open justice means also visibility, and your issue with the publication of judgments added an additional aspect to our debates, and here indeed we really have a changed situation, as so much is so easily accessible today. Also when we are doing our research here at the Institute, Europe-wide, languages are still an impediment, but access to decisions, websites, etc., is totally different compared to the situation 10 years, 15 years, 20 years ago. We have to be aware. One point, because you talked about the anonymization. There is a funny situation in Germany. If you look at a German law journal of the 1920s, you will see the full name of all parties. And all of a sudden, they disappeared. They were anonymized. And I have never found the reason why, frankly spoken. It's still a secrecy. Cécile, would you like to comment on the comments? You have a mic?
No, thank you. Not especially. It was complementary with what I exposed. It was very interesting. About what you said, dear Robert Magnus, indeed, it's a, well, there is maybe, I don't know if we have to switch, if we may, if there is a change of paradigm. It's the question. Can we go on with the same models, the same way of thinking? maybe we are not, I think we are not deemed to a revolution. What I would like to find is a medium way, but it's not easy. I can understand what you said about maybe some excess. I'm not very fond of video conferencing, etc. I precise. Just reading about that, I also saw that video conferencing is also a solution sometimes, where other countries, other systems would propose to suppress the hearing. It's, let's say, a less worse solution, but indeed it should remain exceptional, and we have to find the good techniques. I think also that has to be improved, to have a good frame, technical frame for that. But maybe let's give some room to the discussion.
As we are a little bit late in time, I would permit 1 or 2 questions from the audience. We will have additional time tomorrow. But is there somebody who would like to comment? And please raise your hand.
Frederik Varke from the University of Southern Denmark. I'm assistant professor there. Just a brief question. I think that it would probably mainly go to Professor Robert Magnus. And that is just to understand the difference between this conference and the one we had before. I mean, this is civil procedure. Does that make a difference as to the use of technology? Could we say that the principle of disposition and the Verhandlungsmaxime, or what you would call it, means that we to a large extent can allow the use of technology?
Yes, I think so. I tried to make the distinction there very clear. What I was defending is, I think, in general, the use of a meeting in a courtroom has its usage which is not possible to substitute at all. I think it's a general experience, a human experience, the context, the direct contact, it has its uses, it helps to find solutions. It also helps to see if someone is telling the truth. I think it's quite different if I'm watching someone on a TV channel or if I'm directly present in front of him. So this is something we still need, and I think we always need, and we cannot substitute it. And the other thing is, when the parties agree, okay, we can fly in a witness from the United States. That will cost 5,000 euros. He has to stay here. He has to come from California. Maybe he cannot tell much for the case. So maybe what would be an option? We have a video conference there, and then we ask, what has he seen? What can he tell for the case? And if it's interesting, maybe we can reconsider if we let him fly back here to Germany and have him in the procedure. And I think if the parties agree to such, and you pointed out, it's of course clear we have the maxime that the parties can agree what they want in the procedure and what not, and they have a strong position how the procedure is managed in the civil procedure. If they agree to it, I think then it's fine. It's completely they can decide whether they are willing to save money and cost, and then they have the maybe less ideal interview via video conference. But I think often that won't be happening, because if it's really a decisive witness, I won't agree to have him just on a video. I want to see, is he telling the truth? And I want to see him directly here, and he has to lie to me in the face and not in the United States via video. And because if I would be in such a position, maybe I am saying, okay, the 5,000 euro, it's worth it. I want to see, he has to come here and he has to state what he is stating in his writing. Is it really true or is it not true? I think that would be my position here. I tried to make clear, and I would defend again.
Any additional question? Lady Jen.
Hi, Hazel again. Just to say, it's just a comment really to say that sadly, despite what you've just said, that future is already here. And in the United Kingdom, we are planning to go way, way further, even than video conferencing, to simply fully online proceedings. And we'll talk a bit about that tomorrow. What we lack is any evidence at the moment of the difference that it makes either to the judiciary or to the participants when things are done either by video conferencing or online. We have at the moment, I don't think we have any good evidence about the impact on perceptions of fairness, perceptions of justice, on outcomes. These are all huge questions, but believe me, these things are pretty much already here, not just in the UK, but in other jurisdictions as well. So the future is with us.
Thank you very much also for these remarks, which bridge very well to the next point of our program. But I would first thank to our three speakers.